My name is Olivia Wan, and I'm with the Law Office of Olivia Wan and Associates. In today's episode, we are addressing the question, why does my last will and testament have to be probated? And the answer is the process of probate is submitting your last will and testament to the court, and then the court first validates that the will is in a legal format. There's certain requirements that we have to meet. And in Tennessee, the specific requirements is that the will is attested, witnessed by two witnesses, and there is a self-proving affidavit that is notarized. And so, if we do not meet the legal requirements of a will, then it would be addressed as if there was no will. The other issue is if the person writes on their will, let's say it's a typewritten will, and then the person is just trying to make edits by writing in the changes. Well, those edits would not be acknowledged. So we always encourage people, don't write on your will, have it updated. Now, you could write your will in your handwriting. And if that's the case, then there would be affidavits verifying the handwriting. So it's not as rigid as a typewritten will. So to be clear, a handwritten will is referred to as a holograph. And according to the statute at TCA 32-1-105, no witness to a holograph will is necessary, but the will has to be in the handwriting of the person drafting the will, all the material provisions, and then the handwriting has to be proved by two witnesses, which makes sense. But getting back to probate of your will, when the will is submitted to the court, then the court officially recognizes the personal representative, which we used to refer to as the executor, in their fiduciary capacity. And when the personal representative receives the letters testamentary from the court, they can take this official document to the bank, set up a bank account for the estate, access bank accounts, pay bills, and then finally distribute the assets. And so it's important to recognize that even though you have a will, it would likely be submitted to the court for probate. Now, a way that you can avoid probate is to have a revocable living trust or other types of trust, including irrevocable. Also, making certain that all of your bank accounts, investment accounts, retirement accounts, life insurance, all have beneficiaries listed. So it's a good idea to consult with an estate planning attorney to explore ways that you can avoid probate if that's your goal, or making sure that your will is current and valid so that when it is probated, there are no challenges anticipated. Thanks for tuning in, and we'll see you next week.